it's question time. There are rules I may dispute. Maybe it's a strange place to be for constitutional lawyers. We'll take 3 questions. Please ask 1 question. It must be straight to the point. And then after I've collected 3 questions, we'll hand over to our presenters to respond. I'll also ask them to be straight to the point. So it will be 3 questions. Please state who the question is directed at to make things easier. Then we'll have another round. Hopefully we'll fit in a 3rd round, and then we can move on and have our tea. So the floor is open for questions. What I'm going to do to be balanced, I'll have 1 question from this side, 2 from this side. The next round, 2 questions from this side, 1 from this side. Unless if there are no questions from this side. I saw hands here. Let's start there with Prof. Mia. And you, sir. Sir, you'll be the first in the next round, I promise you. This side, any question? Yes, ma'am, you'll be. In that order, please.
Thank you very much, Professor Stone. I really appreciated your comment that separation of powers, doesn't have the capacity to do all we want it to do. But my question is actually directed at Professor Jackson in that light. So I thought it was particularly acute what you said, acutely relevant for South Africa, that we should bolster political competitiveness rather than separation of powers necessarily. Because once you've solidified power, separation of powers certainly here isn't working the way it should. So my question is very simple, as George requested. I'd be astonished.
So closer to you.
I'd be astonished if you can give a simple answer to this though. Isn't it then true that constitutions, don't have the capacity to do what we want it to do? And then how does it stop a slide towards, let's not say totalitarianism, but a slide towards an undemocratic state?
Thank you, Professor. Sir, over to you.
Michał Jackowski from Poland. A question to Professor Jackson, but the question could be also asked yesterday. We agree that the courts pass the law, the norms, and replace the legislature. But are they really prepared to do it? Because the judges are not taught any legislative techniques or impact assessment analysis. And for example, the example from Poland, two months ago, Polish Constitutional Court disqualified the rules concerning giving a fast track for banks to collect the debts from the debtors. The court gave 18 months to correct the law, but meanwhile, the next day, the court ceased to accept all the motions from the banks, even concerning old debts or old agreements. And the court, in my opinion, could predict it, knowing the discussions about the impact of constitutional court decisions, but did not do it. And there are a lot of examples that could be done. And once more, if we require that judges pass the law, pass the norms, how to solve this problem?
Thank you, sir. So moving on.
Thank you very much. It's a question for Professor Philippe and the European context in general, because I guess you're the representative for Europe here on this panel. So I think when talking about Europe, we cannot talk about separation of powers without talking about the EU, because it has such a large impact somehow. And I think yesterday, Professor Arnold, and today you have talked about how the EU affects the separation of powers at the national level, more sort of, at the national level. But I think we also need to address institutional balance and separation of powers at the EU level, because that plays just as important a role somehow. And it's very interesting that you can actually view some of the same tendencies at the EU level, where you have a lot of delegation to the executive and strong agencies and maybe a lack of political accountability. So you see the same tendencies, and of course this just strengthens the national tendencies. And I guess my question is to you would be then, of course, if you would comment on this development, but also why do you think we view the same tendency both at the national level and also between the EU institutions? Thank you very much.
Thank you, ma'am. Thank you. Now I'll hand over to our presenters. Difficult questions, I think, but they are the experts. Where shall we start?
Thank you. Well, yes, this is a very hard question, the first question. can constitutions prevent slides towards undemocratic, anti-constitutionalist states? And the answer clearly has to be no, they can't. But are there steps that one can think about? And here I want to invoke another body of work that David Landau has engaged with that we haven't talked about yet. A title of one of his articles, where's David, is Abuse of Constitutionalism. And the idea is that there may be steps taken in particular contexts which together have an anti-democratic effect. If you look at the context of political party dominance, for example, or who's holding offices that are being changed. And the tradition in many courts is to look at issues quite separately. And if you're looking at them separately and formalistically, you do not have a basis for saying, no, you can't do this. So the idea, this is my idea, not David's, although he might agree with it, what can be done in a constitutional system to combat this risk, this slide, may require tolerance for, let me give an example, the Colombian Constitutional Court's decisions upholding an amendment to the Constitution to permit a second term for a president, and striking down an amendment permitting a third term. You might say, well, there's no difference in principle, but looking at the context, you can say, at this point, maybe we're moving towards a potential for sliding. I think in the time allowed, that's all I can do as a start on that question. On the question of whether courts can make law, I think probably the whole panel, others on the panel would have views. I don't share the assumption that we all agree that courts can make law. Do courts influence the substance of law? Absolutely. But much more often in what in Europe would be called as a negative legislator, saying what parliaments cannot do. And the system of giving parliaments time to respond, I think, is a pretty ordinary way that constitutional courts deal with the invalidation of statutes. Now, having said that, do courts perhaps have responsibilities to contemplate what happens in the interim? Yes, they may. What's the best way of doing that? I'm not sure. There are probably multiple ways involving hearing from the parties, maybe hearing from the parliament. I don't know the Polish case well enough to comment further on it. There are cases, we heard about the Vishaka case in India yesterday, where the Supreme Court of India issued fairly detailed regulations dealing with efforts to protect against rape and sexual harassment. And I think that might be analyzed in the framework that, again, David Landau has suggested of dynamic constitutional theory if you have legislative defaults, persistent defaults over time. But these are questions of degree. Should there be more waiting for the legislature? Should courts give a nudge rather than simply issuing a ruling? Or another example, both the German Constitutional Court and the U.S. Supreme Court, from different perspectives, issued fairly detailed decisions about permissible regulation of abortion. The German Constitutional Court's decision said, well, you have to be more punitive, you have to be more discouraging. The American court in the Roe case had a trimester framework, and questions were raised about both of them as looking too legislative. So I think this is, again, a very complex question about which more can be said and hopefully will be said by my colleagues.
You want to? Okay. Sorry. Well, a first comment on what has been said by Vicki. I fully agree with the idea that the Constitutional Court cannot transform into a legislature. They can maybe give direction to certain on certain issues where some of the provisions are unconstitutional, but I think that if you transform the Constitutional Court into a legislative power, it can be more problematic than resolving problems. Coming back, turning to your question, well, I didn't actually dig into that, but it's clear that the European institution, being the Council of Europe or the European Union, has dramatically changed the separation of power, or our vision of separation of powers. And you're right when you say that it's actually at a twofold level. First, within the EU institutions, And on that point, I would say that unfortunately, or fortunately, I don't know, the existence of the European Union is not so old. So the mechanism have not yet been developed. And we have to be very careful because, for instance, if you take the powers of the European Parliament, the power of the European Parliament are not the same than the power at national level. The co-decision procedure means that the Council still is word to say. So the comparison is very tentative, but at the same time we have to be very cautious regarding the comparison we can make. But what you mentioned as well is true regarding separation of power between the EU institutions and the national institutions. Because sometimes there is a game that is played between the executive and the legislative at national level that is not clear. When everybody says, I mean, at national, the government says at national level, well, that's Brussels, that's not us, okay? Brussels being the seat of the Commission and the European Parliament, partly at least. Then who sat in the Commission? The government representative. So they knew exactly what they did. That means that the executive was part of a decision that will apply then to the national legislative. To such an extent, for instance, that in France during the 2008 amendment, in the 2008 amendment of the Constitution, there has been a provision saying that each project of directive should be first submitted to national parliament, so that they can have a look on what has been done. Okay, so that is probably something that has to be digged on and reshaped. Finally, I think that there are newcomers into this dispensation of powers at European Union level. For instance, lobbies. It's interesting to follow the route that is made by a new text. And you can see that not only European Parliament, not only the Commission, but some private parties who come and try to advocate for this, that, and that. What they did not succeed to have at national level, they try to have it at European level. So yes, it's a full reshaping that needs to be studied, and probably we have a lot to learn on that. Thank you.
The only further remark I want to make is just in response to this question about courts behaving like legislatures outside their institutional capacities. I just want to remind us really that there have been attempts to reconfigure the relationship in ways that respond to the institutional strengths of legislatures in courts, and I'm referring, of course, to the forms of weak form judicial review that characterise parts of the common law world. And there are very well known critiques of those systems. They tend to morph, it's said, into either strong form or back to no judicial review. But I think the history of them is short, very short, and there's considerable more room for creativity about creating ways for courts and legislatures to interact in ways that respond to their strengths. For example, by courts not ruling things invalid, but sending them back for a redrafting and a second look. So I just want to put those back on the table.
Thank you very much. Now I have a second mic, so I'll be able to interrupt you. We're almost, we're closer to tea time. I'll ask the next, group of colleagues that will be asking questions to be really straight to the point. Ask your question, sweet and short. And I'll also ask the panel to be sweet and short. 11 o'clock we're breaking for tea. So it's your, you are noted, and let me get to the next two from this side as promised. Gone. Any more questions from this side? Yeah. Oh, no, you are noted. I just want to collect two more, then we have three. Otherwise, then the floor is yours, sir.
I don't want the floor. I want to stay in my seat. I guess I'm going to address Vicki and ask her, well, the interesting thing is, sidebar, the first article I ever wrote was on Section 106 of the Immigration Nationalization Act, and directly engaged Chada 25 years ago, which makes me feel very, very old. But I just want to ask, there's been a discussion about fourth branches of government here, and we have these institutions which are what I believe to be largely white elephants because the government never funds them sufficiently to do anything meaningful. What I wanted to ask you is a different question. In the United States, having practiced there for a while before coming here 20 years ago, it struck me that there's a real dynamic fourth branch of government. And those administrative courts are quite important in the way decisions get made, because they're specialized courts, because there are multiple actors within those courts. I've been a representative in family court, representing a child, and there have been 6 other lawyers and a specialized judge in the room. Immigration courts are the same way, and so are drug treatment courts. So I wanted to ask you just a general question. I find there to be a great deal of dynamism in that fourth branch of government, and a better way of solving problems often than comes out of courts at working at a very rarefied level, legislatures somewhat less rarefied, executives possibly acting in an imperial fashion. So just on that fourth branch dynamism.
Thank you, sir.
I also have a question for Professor Jackson. Lawyers tend to be preoccupied with the role of courts and with rights protection. But in the introductory remarks of Professor Landau, he pointed out that legislatures, and I think it is a real issue in South Africa today, are experiencing a loss of power and legitimacy. So I'm intrigued by your observation towards the end of your presentation that steps should be taken to strengthen the representative branch of government as an aspect of our commitment to constitutionalism. So my question is, why you think that is the case? Why should we be worried about the decline of legislative power? And secondly, what steps do you think could be taken to address this decline?
Thank you, sir. There's a last question on the other side of the there.
I think it's a question for the three of you. I think that the conversation has focused on separation of functions and checks and balances. And I wonder if the principle of harmonic collaboration has played a role, if any, in this, in your countries and in general, in the reflection, the thinking about the content of the principle of separation of powers.
Thank you, sir. Now over to our presenters, 1 minute each. Sweet and short.
So you shouldn't have this
I just have one quick
Sure,
thing.
sure.
So just on the collaboration point, I think that's actually the idea behind the dialogue models, right? The Canadian dialogue model. I do think that's what they're trying to get to. And I think that the fate of them, which is problematic, shows the difficulty of really getting institutions to really act cooperatively. I actually think, rather than thinking about collaboration, I think we need to find the most productive forms of interaction. And I think we need to take the warmth out of the concept of the relationship because it's too much to accept. But forms of interaction that are more productive, I think, ought to be on the table, but they are in some ways.
Also a quick word on that. On harmonic collaboration, I think that if we speak about the 3 classical branches, there is an harmonic collaboration, and that cannot be something else because they need to work together. I'm a little bit more pessimistic regarding the newcomers. They are not necessarily taken into consideration as they should be. The 4th branch, nobody knows really where they are. So sometimes when it comes to the collaboration between the legislative and the executive, and even the courts, even the Constitutional Court, things can work and they're adaptable. When it comes to the new institutions, the private parties, the powers, then things can be more tricky. And there is a claim actually from these institutions, especially from the private parties, when they want to participate to this separation of powers, this sharing of powers, that they are not sufficiently listened to.
Thank you. I'll take them in that order as well. U.S. constitutional culture does not have a principle of cooperation or collaboration in it. On the other hand, we have many schemes of cooperative federalism that in practice depend on a certain degree of cooperation. In terms of moving from that to the question, why worry and what are the solutions to the loss of legislative power? Who asked? Oh, over there. One of the worries I have is that for a period of several years, compromise became a dirty word. People ran for office in Congress saying, I will never compromise. Now, if you're in a heterogeneous democracy, this is a fatal attitude to have developed. So in other work I'm doing, I'm working on the virtues of being a representative, including knowing when to compromise. It's not exactly the same as harmonic collaboration, but not irrelevant. Now, why worry? Well, why worry? I worry about atrophy of the skills of being a democracy. That's what I worry about. I worry about all policy being made through special interest groups, even if they're interest groups I believe in. I worry about the loss of capacity to have a general governance. Those are my why worries. What to do about it? Here, great difficulty. I have many ideas, but when I play the ideas out, they might be good, they might be bad. For example, in some countries, courts will review inadequate legislative procedures and will say, no, an amendment that was added 4 hours before the bill was sent to the president with no hearings, no signature, overriding a law that took 12 years to put into effect. There are courts that would say, no, this part isn't valid. You didn't consider it. You didn't deliberate it. There was no opportunity for discussion. Not so in the United States. Would we improve things or not? However, it's complicated. It might be such a doctrine could be used to disrupt the democratic output. So I think that's a very hard question, but a good research agenda for the future. And coming to the last question about the dynamism of the kinds of courts you're talking about, the kinds of courts that Professor Woolman was specifically addressing exist primarily in our state court systems, not the immigration court, but the family court, the drug courts. And indeed, the generic term for them is sometimes called problem-solving courts. And it's very satisfying to see this work, and there's been tremendous innovation. I totally agree. What are the problems? They are the problems you would imagine when you're doing things one case at a time. How do you assure the equitable treatment of others in the same situation? That can be hard. And there are many other hard things, but I've been asked to limit my remarks, so that's a start.
Okay. All right. Thank you very much, ladies and gentlemen. Please join me in thanking our wonderful panel for a job well done.
The University of Johannesburg. Rethink, reinvent.